is entitled.
There's an old trial lawyer saying, if you have the facts, pound the facts. If you got the law, pound the law. If you don't have either, pound the table.
Is entitled.
So are the laws on our side, the facts on our side, or neither? I'm Lainey Law.
And I'm attorney Andrew Myers.
And I have a feeling we are in for a doozy of an episode today, considering all of the news that's been going on.
Well, from the time of a somewhat combative hearing in the Norfolk County Superior Court in Dedham in the Karenread case, we've had a little bit of time to digest. When the hearing went down and Special Prosecutor Hank Brennan had some, I hate the word bombshell, but he had some allegedly bombshell material. And the judge, said she was very concerned, and we'll give you the exact quote in a couple of minutes, and stormed off the bench. People right away were scratching their heads and the opinions were all over the place, but we've had a little bit of time to digest all of this, which apparently was not done by the special prosecutor, who came in loaded for bear in a hearing on Tuesday, the 18th. And he was upsetting the judge by saying that, or alleging that there were some communications between the defense team and the supposedly independent ARCCA expert, particularly Daniel Wolf. And setting the tone for the theatrics in the courtroom that day, Special Prosecutor Hank Brennan seemed to say that he got all this information surreptitiously from the federal government.
So I called the federal government and I tried to encourage them to provide full discovery so that the experts could testify. I was resigned to a TUI letter. I've been down that road many times. It's a dark road that never sees the light of day. So I filed the TUI letter, comprehensive TUI letter. And it was delayed. And over a long period of time with requests and deadlines, I finally received a response that was unresponsive. And it was striking that it wasn't noted as unresponsive, just when I read the materials, and Attorney McLaughlin actually identified them. They didn't respond to our request, so Attorney McLaughlin wrote back. And then we got new materials, just some. But these materials are the very reason why the defense should not be able to call witnesses without giving full discovery.
Which was kind of a contradiction, because he started out the whole colloquy to the court by saying that, I don't care if they testify. I'm not against them testifying. And that was the theme. He said he wanted the discovery.
Having not been at the last trial and reading the transcripts, I only have a flavor for the last trial.
Yeah, remember earlier when he first came in, he got a lot of heat because he said that he hadn't watched the whole trial. Well, now he's read the transcripts.
So there is email correspondence between the defense, not only the federal government, but the ARCCA witnesses themselves. A recent request for their appearance pursuant to TUI, which I have no issue with. But if we look back earlier in the relationship, what we see back in March 22nd, 2024, is that there are conversations between the defense, Attorney Jackson, and Daniel Wolf, who's one of these ARCCA witnesses. Okay,
so what's the extent of the communications and where did he get the information? He's about ready to launch into an expose of all of that. But again, he prefaced it all a second time by claiming that he got all of this information from the federal government.
Now, this isn't information provided by the defense in reciprocal discovery. This is information provided by the federal government after numerous requests, TUI requests, and an insistent, the best I can, to get as much information as I can.
And that was a misstatement.
We then are provided an outline of questions and answers for a direct examination. The Commonwealth did not have the luxury, the privilege, did not even know that there was an outline that was being disseminated by this totally independent witness who took no side other than that of the truth. What follows from this outline is then the outline with remarks from this independent expert who knows nobody.
Look, the sarcasm there. Independent expert who knows nobody. I mean, I don't know. There's such a thing as ethos and pathos and logos and doing theatrical presentations. And I don't know, in a case of this magnitude, in front of everyone in that room, including the judge. All right, I should restrain my commentary, but it just seems like a lot of theatrics went into this presentation.
So we see in the margins in the notes, this fair-minded, objective witness says, so not being able to inspect the vehicle is something that's not uncommon in your line of work, and he writes, absolutely not, and then he comments, not sure if you want to put this somewhere in the direct examination. I have a feeling they, the Commonwealth.
Okay, and he went on and he talked about there were some notes that he uncovered, he says, from the federal government, but he'll later admit that, oopsie, it was actually, this information was presented by the defense attorneys in discovery just like 5 days before this hearing. And he read off some electronic communications that were apparently said in the recently produced emails to have taken place between the ARCCA experts and attorney Alan Jackson.
What we see back in March 22nd, 2024, is that there are conversations between the defense, Attorney Jackson, and Daniel Wolf, who's one of these ARCCA witnesses. Thank you so much for taking the time to get on the phone with me this morning pursuant to our conversation. Please feel free to forward an engagement letter to this email address. I will get that countersigned and returned to you forthwith, along with your retainer as required. The Commonwealth, as I understand it, was not aware of any promised rewards or inducements or payment. They relied on a reciprocal discovery order of this court for that information. Response, hi, Alan. Subsequent to our conversation on Wednesday, the U.S. Attorney's Office asked we pause any further conversation until we received additional information from their office regarding how our involvement will move forward. And then a bill from ARCCA to the defense for $23,925.
Okay, now I'm aware that out there are posts, there are social media explanations that there was a payment by the Department of Justice. That has yet to be authenticated and verified. And in the legal sense, we need authentication. There are also allegations out there that the defense team paid for some costs. That, again, has not been authenticated. And so this is a legal channel. I'm aware of all the other channels. I'm aware of the social media buzz out there about the case. But I want to keep my comments restrained to what has been stated in the open court and what has been authenticated, and payment of anything at this time. And yes, I'm aware of the documents that have been placed on social media, but there's no authentication that the defense team paid anything at all. But this was enough. The two central allegations are that there were communications between the defense attorneys and the ARCCA experts before the trial, and there was some discussion of payment. This was enough to infuriate the judge, and I'm only saying that based on her conduct, she was furious. Now, whether she was furious at the defense for all of this or the way it was being presented, so she stormed off the bench and she said she'd be right back. She was out for 20 minutes. When she came back, she didn't seem to have cooled off a lot.
So the Commonwealth just provided the court with information that causes me grave concern. The implications of that information may have profound effects on this defense and defense counsel. So for that reason, I'm going to suspend today so that when we meet again to address these issues, all affected will be appropriately prepared. So I'll see you a week from today at 11 o'clock in the morning. You can tell me now if that is impossible for you.
So now she's shaking.
You sounded very upset.
She's very upset. Look at her. Her hands are shaking. She puts her glasses down. Her hands are shaking. The glasses are shaking. She's very upset. There've been a lot of talk about why And it seems to me she's upset about something. It seems to me that had we all been cool and calm and collected, and yes, I know that Monday morning quarterbackers in hindsight are perfect, but the temperate thing to have done, to the extent that Mr. Brennan may have dropped a bombshell. Boy, I hate that word, but now I've used it twice, haven't I?
I mean, it's the hot buzzword for court.
But to the extent that Mr. Brennan did unveil anything that is untoward, the practice that would have been best would have been to immediately give the defense attorneys. I mean, they appeared ready to explain their side of the story.
Mm-hmm.
And bear in mind that all this stuff was provided by the defense. So do you think that the defense would have provided all of this information had they not had an explanation available?
Yeah, well, and I think that's a good point where it's just like saying that it's like from the federal level versus saying it's from the defense as completely different things. The defense is completely aware that that information is out there.
So it would seem to me that the best practice would have been to say, okay, Mr. Jackson, explain yourself and give him the opportunity to explain, because now we have a cliffhanger, a phony cliffhanger like the old days radio and TV shows is there. And they were sent packing and said to come back a week later. And all of this, it is a major cliffhanger. And only after this, Mr. Brennan shot up and he felt the need to explain himself, but only then under the guise of giving the court a timeline of what had happened did he admit that the information he had dropped earlier in the morning was not from the federal government, but it had been produced directly to him by the defense attorneys.
The defense provided us the emails that I read, February 13, 2025. I think I said the federal government. It was the defense. February 13, 2025, they sent us the emails and the direct examination outline.
Oopsie. That's kind of a big oopsie, don't you think? I mean,
It's a
that's
huge
kind
difference.
to me, that's a big issue. I don't know.
Well, especially if that's the reason that she was upset. Like, we don't know like what was going on with her, but if that's what had upset her that much.
Yeah, exactly. So going through all of this and putting on my thinking cap, I'm saying to myself, what are the real issues here? What are the real issues that have been raised? And I've come up with two issues. And the first one is, what is actually in the communications between, or the alleged communications between the defense team and the ARCCA experts? And I don't think that's really necessarily going to be that big of a deal. I really don't. The second question is, did Alan Jackson or the ARCCA expert lie in court? Now, that would be a big deal. That would be a huge deal.
Mm-hmm.
And so I'm just thinking to myself, I don't know. So I think to answer the second question, we have to go back in time to the trial of Karen Read back on day 30 on June 24th of 2024, when ARCCA expert Daniel Wolf was examined before the jury in that trial. And so we got to take a look at this really carefully and see, what really happened at that time.
You were not hired by the defense in this case, correct?
That is correct.
At the time you did your expert review, Dr. Wolf, and your consultation, you and I had never met?
That's correct.
And so at that time, that would have been way before the trial. And so that,
You did not know who I was?
I did not.
You'd never met Ms. Little?
No.
Mr. Unetti?
No.
Matter of fact, you'd never heard of this case?
That's correct.
And so there's nothing wrong with that, because that at that time when the ARCCA experts actually did their analysis was before this trial and before March of 2024, when the communications that Mr. Brennan just talked about took place. So nothing bad so far.
You were hired by another agency not connected in any way to the defense, is that right?
Correct.
And not connected in any way to the Commonwealth, is that right?
Correct.
So your analysis and your conclusions and your opinions are completely independent of the defense and the Commonwealth in this case. Is that right?
Objection.
Sustained. Mr. Jackson, you can ask it differently.
When you did your analysis and conclusions, well, let me ask it this way. You finalized your report, you and your team, correct?
Correct.
That report is contained in a multi-page document that was submitted following your analysis and your opinions and conclusions, right?
Correct.
The defense didn't have anything to do with that, correct?
Correct.
You had never met us, didn't know who we were when you did this.
Correct.
You'd never met Mr. Lally, didn't know who he was when you did this.
Correct.
So your analysis, opinions, testing, and conclusions were requested by a completely separate agency.
That is correct.
All right. Goes without saying, but I'm gonna ask it anyway. You haven't been paid by the defense,
You have not paid us anything, no.
and you don't work for us.
That's correct.
As a matter of fact, I've never asked you specific questions about your testing before today.
That is correct.
And do you think that if they had paid something, do you really think that Alan Jackson would have gone through that? Because bright attorney, no matter what you think about him, and I know we've had some comments down in the comments section about Mr. Jackson, but he is a well-known attorney. He's an experienced attorney. Do you think that he would actually go through that colloquy with this witness in court if there was money trail that he paid?
And then to provide that evidence to the prosecution.
I mean, so I don't see anything wrong with anything that was said in that back and forth. And then after that, and we're not going to go back and replay the whole thing from June 24th of 2024, because we were doing episodes about the trial, and we did do an episode that included the ARCCA experts. So he just launched back into the facts and opinions that the ARCCA experts had gone through. But so, you know, getting back to the time that we're talking about when Mr. Brennan brought forth all of this information saying that it was from the feds, then the judge storming off the bench, and then Hank Brennan coming back and saying, oh, oopsie, it was not from the feds. It was provided to me by the defense. When the judge came back, she was shaken. She seemed to have her composure during the earlier part of the hearing when Mr. Brennan was going through his theatrical presentation. Yeah, Hank, it was theatrical. And it was only after she stormed off, and she said she'd be right back, but 20 minutes is a long break. So you might ask, what made her shake like that in court? Was there something else that happened? Well, yeah, something else happened that day. The appellate team for karenread filed a memorandum in support of their petition for a writ of habeas corpus. And for our viewers who don't know, I think everybody knows what that is, but that
everyone.
it's a petition, actually habeas corpus, to save the body. Now, as they explained herein, she's out on bail, but she's still under the direct purview of the court. I mean, if anything happens, her bail can be revoked. So petition for habeas corpus can be appropriate in these circumstances. And in this memorandum, they point out that Judge Cannone, allegedly, according to the appellate attorney, made some serious mistakes in this case. Now comes the petitioner karenread by and through the undersigned counsel, and hereby respectfully submits this memorandum in support of her petition for a writ of habeas corpus. Ms. Reed is currently facing an April 1st, 2025 retrial in the Norfolk County Superior Court after a prior mistrial in July 2024. This petition contends that such a retrial will violate Ms. Reed's 5th and 14th Amendment protections against double jeopardy. The petition relies upon post-trial statements of 5 jurors, 4 directly and 1 indirectly, that the jury in Ms. Reed's first trial reached a final unanimous decision to acquit her of second-degree M. Despite massive media publicity regarding these declarations, none of the other 7 jurors disputed the accuracy of these post-trial statements. In the usual course, the jury's verdict would have been announced in open court, and a re-prosecution for that charge would indisputably be constitutionally prohibited. Here, however, the trial court, assuming but not verifying that juror notes indicating an impasse referred to all rather than just several of the outstanding charges, failed to inquire pursuant to Mass Rule of Criminal Procedure 27, which regards the existence of any partial verdicts, as well as failing to poll the jury. So this is when, this is only a summary. We're going to get into it much more deeply, but this is when Judge Cannone might have said, I got it past the state Supreme Judicial Court, but now the federal court is going to take a look at this.
But I don't know, like, given everything that's happened, Do you think that she would be worried about this on the federal level because they didn't care before?
I don't know. If somebody filed some federal paperwork against me, yeah, I think I would be.
Fair.
As we'll say, this, and again, it's only alleged, it's only by the defense appellate team, pointed out some mistakes she made. Contrary to longstanding federal as well as state case law, the trial court gave no consideration to any of the existing viable alternatives to a mistrial, nor was defense counsel consulted or given any opportunity to be heard prior to and in relation to the court's declaration of a mistrial. At no time prior to the trial court's final sua sponte decision, that means on their own, that's Latin for on her own, without consulting anybody, decision to respond to a jury note by declaring a mistrial, had the trial court even mentioned the word mistrial. In these circumstances, the Commonwealth did not satisfy its heavy, well-established burden of establishing manifest necessity as a condition precedent for the mistrial, which was declared in violation of Karen Read's double jeopardy right. So what she's saying there, what her appellate attorney is saying there is, Judge Cannone turned the law on its back, and the Supreme Judicial Court, all 7 of them, yes, there's 7, failed to recognize the fact that it's the Commonwealth's burden to prove manifest necessity. And this has been turned on its side by saying, oh, no, the defense failed to prove it. So the defense independently maintains that a jury's final unanimous agreement that Ms. Read is not guilty constitutes an acquittal for double jeopardy purposes, and that the trustworthy and uncontradicted post-trial affidavits entitled her, at a minimum, to a judicial inquiry on this issue. The prosecution wants this court to, in essence, ignore the declarations of the jurors, ignore the possibility, if not probability, that the jury unconditionally, finally, and without any ambiguity, unanimously found Ms. Read innocent, and avoid any post-trial inquiry that could demonstrate that all 12 jurors unanimously rejected the sufficiency of the prosecution as to 2 of the 3 indictments. So I don't know if it would make me shake, but good public policy argument here, not necessarily a strictly legal statement, but public respect for the judiciary requires that the agreements reached by a jury of the defendant's peers in a matter so consequential need not be rendered irrelevant. For these reasons, federal courts favor post-trial voir dires, and the denial of such inquiry here violated Ms. Read's 5th, 6th, and 14th Amendment federal constitutional rights.
The post-trial voir dire, why is this asking for so much? It feels like technology and the court are on completely 2 different universes.
They sure are. Right?
Or like even just have them anonymously vote on a computer. They put in their votes and then they tally it up and then they see if they come to an agreement and then work on it from there.
I agree. Why not? I mean, this is 2025. This isn't 1925 when, people would have ridden horses to the court.
Yeah.
So the appellate brief goes into the procedural background. We'll spare you all that because our viewers know all of this. They sat through the trial with us, and they've sat through some of our post-trial comments. And so we're going to get to the parts that might have made a judge, yes, even a judge, shake a little bit. The underlying idea, one that is deeply ingrained in at least the Anglo-American system of jurisprudence, is that the state, with all of its resources and power, should not be allowed to make repeated attempts to convict an individual for an alleged offense. Even if the first trial is not completed, a second prosecution may be grossly unfair. It increases the financial and emotional burden on the accused, prolongs the period in which she is stigmatized by an unresolved accusation of wrongdoing, and may even enhance the risk that an innocent defendant may be convicted. And this is all supported by some case law that they've put in here. So in other words, let's not put form above substance. If the jury did, in fact, unanimously agree, and we're going to get into this a little bit more when we get into a juror interview, It doesn't matter if the form wasn't there. Remember, we said before, well, it wasn't announced in open court. What the appellate attorney is saying here is that presumption flies in the face of some United States Supreme Court precedent, which they cited. Reprosecution is barred because there was no manifest necessity to declare a mistrial on counts on which the jury was not deadlocked. As a general rule, the prosecutor is entitled to one and only one opportunity to require an accused to stand trial. Importantly, the heavy burden of establishing manifest necessity to justify a mistrial is exclusively on the Commonwealth. And they cite a law, a burden that the state courts erroneously placed on the defendant. When it says state courts, read Judge Beverly, Cannone. In assessing whether the prosecution satisfied its burden on this point, the First Circuit has stated it is useful to consider the following three factors: whether the trial court consulted with counsel, 2, whether the court considered alternatives to mistrial, remember Rule 27, and 3, whether the court adequately reflected on the circumstances before making a decision. So this is federal law. This comes from the First Circuit. We're in the First Circuit. And it's a relatively recent decision. 2019 is like yesterday in the law.
Basically, yeah.
So,
And I think it makes a good point.
What?
Well, I was going to say it makes a good point in just the fact that this trial happened and it's already such a financial burden on the person where it's just like, okay, there was a mistrial. Well, something went wrong on the court's end and all this money is going into the court. And then also like the defendant also has to pay for all their attorneys and stuff like that. It is an impossible financial burden for just like any normal person. Like if this were me or anybody watching this channel, we would be absolutely screwed if we had to go through this court again. How much time is she spending in court that she can't even go to work full time? This is crazy. Turning to the relevant factors, the first thing to be noted is that the trial judge did not give counsel an opportunity to object or discuss with them the advisability of a mistrial. Upon receiving final jury note, the court declared a mistrial and excused the jury without consulting counsel. Video footage reinforces the suddenness of the court's action and the corresponding lack of any meaningful opportunity to be heard. At approximately 5 hours, 47 minutes, and 25 seconds marks of the video, the court took the bench and stated the jury is at an impasse. In contrast to the procedure followed as to prior notes, this note was not read to counsel. Instead, the court immediately called for the jury to be brought in. The sound of the door opening or closing can be heard, and then approximately 5:47:55, a mere 30 seconds later, the jury arrived in the courtroom. The court then read the note, which had not previously been provided or read to counsel. On the record, at 5 hours, 49 minutes, and 23 seconds, the court stated it was declaring a mistrial and immediately discharged the jury at 5 hours, 49 minutes, and 30 seconds, a mere 7 seconds later. These circumstances did not provide Mrs. Reed's counsel with a meaningful opportunity to be heard.
And that's really significant. Moreover, the defense respectfully submits that given the importance of double jeopardy protections and the profound implications of a retrial for a criminal defendant, an opportunity to be heard must, not might, may, could, must, in order to be meaningful, occur after a reasonable opportunity for counsel to consult with their client. And in that, I remember we ran that video a number of times. She declared a mistrial, and that was it.
Mm-hmm.
That was it. There was no. She didn't say, all right, prosecution, what is your opinion with regard to manifest necessity? Okay, defendants, what? No, just I'm not going to do that to you, and that's the end. We're not going to inquire into it. I'm just gonna take a look at my newspaper now. So, and here's another reason why, if she had time to read this in those 20 minutes, she might have been shaking. The record is independently lacking on the second prong, as it reflects no judicial consideration of alternatives to mistrial. Here, there was one obvious alternative: to simply ask the jury to specify the charges on which it is deadlocked and or ask the jury whether or not its final note related to all or less than all of the charges. And this is according to federal law. Federal law says that these options must, not could be, like Rule 27 says, but must be considered. This option is apparent from the face of Mass Art Crim P 27B, which states that the judge may, there's that word again, the judge may declare a mistrial as to any charges upon which the jury cannot agree upon a verdict, provided, however, that the judge may first require the jury to return verdicts on those charges upon which the jury can agree and direct that such verdicts be received and recorded. In fact, the reporter's notes expressly indicate that such reception of partial verdicts is required before a mistrial may be declared for manifest necessity. Now, in our rule books, or now they're online, you can read the rule, but my criminal procedure, civil procedure, and constitutional professors, all three of them, and I can remember them telling me this, you always read the reporter's notes. You don't just read the rule, because the rule was generated by a committee of attorneys that meet together, in this case, in Boston. And it's a bunch of different attorneys, and they argue, and they drink their coffee, and they go out in the hallway and talk some more. Then they come up with the rule. But what's really important, and those professors I just mentioned, all of them said, always read the notes behind the rules, because that's the only way you'll understand the rule. And what the appellate attorney, Mr. Weinberg, is saying, the reporter's notes expressly indicate that such reception of partial verdicts is required before a mistrial may be declared for manifest necessity. So there was a screw up after a 2.5-month trial and 74 witnesses. There was a screw up. That's what Attorney Weinberg is saying. There was a screw up to go through that amount of testimony, even if it was a 5-minute trial, but in this case, 2.5-month trial, to just so quickly say, yeah, all right, mistrial, time for lunch.
Yeah, we'll get back to it in a year or two.
Time to go buy the fireworks up in New Hampshire. It's not funny, I know, and people down in the comments, blast me all you want, because it helps our algorithm. People blast us all the time for making light of these things. But
The whole situation is just crazy. Sometimes humor is like the only way you can get past like how insane all of this sounds. Because imagine having to spend this much money on attorneys, this much time, this much mental capacity. Like if you're in the defendant's position, you're losing your mind. Your whole life is at risk.
yeah, and it's destroyed her life. I mean, you know, yes, I do have sympathy for her. If you don't like the fact that I said that, comment down below. I hear it all the time. But I want you to, before you do that, no, after you do that, after you tell me what a jerk I am, this is a really important passage in this appeal, and I think it should carry the day. With the record barren of any hint whatsoever that the judge was aware of the double jeopardy implications of her decision, the defense respectfully submits that this court cannot find that her discretion was sound. Remember, a lot of this hinges on a lot of things that a trial judge does, but in particular, the granting of a mistrial. It's within the sound discretion of the trial judge. Well, citing case law, federal United States Supreme Court case law, the attorney is saying that with the record barren of any hint whatsoever that the judge was aware of the double jeopardy implications of her decision, the defense respectfully submits that this court can't find that her discretion was sound. It was unsound. The statutory prohibition on ordering the jury to continue deliberations without consent was one among many factors that the trial court should have considered in consultation with the parties. The statute would not have prohibited the trial court from simply asking whether the jury had reached a verdict on any counts, or asking the jury whether its impasse related to all or less of the charges. Contrary to the Supreme Judicial Court's suggestion, there is simply nothing coercive about asking a jury whether it has reached a verdict on some but not all separately charged counts. Remember, we discussed this before. One of Judge Cannone's explanations in her decision upholding the granting of a mistrial was, well, you know, the jury's deliberations are sacrosanct. We are never to ask about the jury's deliberations. Remember that? Well, this is not the deliberations. This is the final result. We're just asking them
what came out.
Yeah. Did you reach a verdict on counts 1 and 3? What about 2? Did you reach a verdict or not? Contrary to the Supreme Judicial Court's suggestion, there is simply nothing coercive about asking a jury whether it has reached a verdict on some but not all separate charges. You know, I always say that you gotta look at the footnotes. You gotta look at the footnotes. The federal constitutional burden to justify a mistrial is clearly on the Commonwealth. Yet the state court, Judge Cannone, not only failed to identify that burden, but improperly placed the burden on the defendant on subjects such as the consideration of alternatives. So maybe this was why Judge Cannone was shaking. I don't know.
Well, is this something where if they look at this and think, like maybe the defense is right here, is this something that could impact her job? Like, could she lose her job over this? No.
It takes an awful lot. I doubt that. It's a legal difference. It's a legal difference of opinion. A horrible difference of opinion, in my opinion. But again, let us know down in the comments what you think. We're almost done with this, and then we're going to get to one other thing. If we have time, we're going to take a look at what one of the jurors told Aiden Kearney, which sheds some light on this. The jury's unanimous conclusion following trial that Ms. Reed is not guilty on counts 1 and 3 constitutes an acquittal and precludes re-prosecution. What constitutes an acquittal is not to be controlled by the form. Remember, it was stated by many, including us, kind of, sort of, just when we're talking out loud, that, well, the jury verdict was not announced in court, and so therefore it's not official. Hey, let's not judge form over substance. This one, as you just said, this woman's life is, on the stake. She could be behind bars if the second trial goes that way. But anyhow, what constitutes an acquittal is not to be controlled by the form of the action in question. Rather, the court must determine whether the action actually represents a resolution, correct or not, of some or all of the factual elements of the offense charged. Labels, including those provided by state law, do not control the analysis. This is because whether an acquittal has been occurred for the purposes of the double jeopardy clause is a question of federal, not state law. Interesting. In rejecting Ms. Reed's claim of acquittal, the Supreme Judicial Court relied solely upon the lack of a formal verdict returned, received, and recorded in open court. This reasoning is rooted in a formalism that has been consistently rejected by the Supreme Court, the United States Supreme Court, in a string of precedents spanning more than 100 years. And so what the appellate attorneys are saying is, all these people, including the judge who said that, oh, no, the verdict wasn't announced in open court. That's it. Done. Walking away from it. Gonna go buy our hamburgers for the 4th of July now. Nuh-uh. The appellate attorneys here cite a fair amount of United States Supreme Court precedent saying that view is rooted in a formalism that has been consistently rejected by the Supreme Court in a string of precedents spanning over 100 years. So we're going to skip over some of this. The defense respectfully submits that this court should hold that Ms. Reed may not be forced to stand trial a second time for an offense a previous jury found her not guilty of, simply because such final unanimous agreement was not announced in open court. Any lack of formality does not supersede the defendant's fundamental, I would add, substantive constitutional protections, and I would add right. So that's their argument to, oh, well, the verdict wasn't announced in open court. All done here. Alternatively, and this is your argument, alternatively, a defense is entitled to oppose a verdict judicial inquiry into determining whether the evidence supports the juror representations as having acquitted Ms. Reed. Actually, I was wrong about that. Your issue was let's bring them back. Let's bring them back. Recently in the United States versus Tsarnaev, remember him? That's the, now found guilty Boston Marathon bombing. The First Circuit remanded the matter for further proceedings in the Boston Marathon bombing case due to 2 jurors posting on social media regarding the bombings and the district court proceedings, which came to light after the jurors had been provisionally selected to serve. The comments did not reflect racial bias in any way, but rather possible bias specific to the defendant. The comments were also inconsistent with jurors' assurances that they had not discussed the case online. Now, there's a couple of issues here. What the Superior Court Judge Cannone had said was, well, the case law does not allow us to bring a jury back unless there's very, very limited circumstances. For instance, racial bias. If there was racial bias, by all means, bring them back. And so she said there wasn't that. So, it's okay. No, the federal law is, and the federal court in Boston has said, no, wait a minute. This guy said that he, hadn't made any discussions of the case online, but there it was. They found it. And so on that and other grounds, by failing to inquire about these issues with the jurors, given that the right to an impartial jury is a constitutional bedrock when there's a plausible claim that a prospective juror lied, where here, Mr. Tsarnaev, jurors, apparently a couple of them went on social media and discussed the case, but then they went into the courtroom. No, Mrs. Cleaver, we haven't discussed the case. So this is just an example of when a court can, in fact, inquire of the jury. Where there is a plausible claim that a prospective juror lied in a manner that may reveal bias, a court need conduct some inquiry reasonably calculated to determine whether the prospective juror did lie, and if so, why. Although the district court has broad discretion to determine the type of investigation into juror bias warranted by particular facts, notwithstanding this broad discretion, a district judge does not have discretion to refuse to conduct any inquiry at all regarding the magnitude of the taint-producing event and the extent of the resulting prejudice if confronting with a colorable claim of juror misconduct. Critically, for present purposes, the First Circuit ordered the district court to voir dire the jurors 9 years after the trial. In doing so, the court acknowledged no doubt any juror would have strong incentives to avoid admitting having committed perjury during voir dire. We also expect that most jurors, having taken time out of their daily lives to receive evidence at trial, deliberate with other jurors, and reach a verdict that they believe is just, would prefer not to have the verdict disturbed, especially as a result of their own actions. We have no doubt that the able district court judge can do what judges regularly do, form a considered opinion about the sufficiency of the juror's explanations once those explanations are given and explored. So the court is saying, yeah, there are all kinds of different grounds legitimately for bringing jurors back, and this is one of them. Contrary to the SJC's characterization, the defense request did not seek to probe the content of juror deliberations. We've said this all along. To the contrary, the requested inquiry was directed solely to the result of such deliberations, namely a unanimous decision that Ms. Reed is not guilty of M in the second degree. Juror testimony on that subject is not prohibited by any law. So that's as far as we're going to go. The Commonwealth has been ordered to issue its opinion or its reply brief, and then this will be heard in early March. So I don't know. I just think that might be one of the reasons the judge was shaking. I don't know.
Yeah, and that's a good point. Like we said, we don't actually know why the judge was shaking, because for me, and everybody's different, but if her job is not actually at risk and maybe she's getting like a slap on the wrist, like, is that enough reason to be shaking? I don't, and maybe something was going on that we don't know, but it did seem like she was shaken up. It did seem like something was going on. That's obviously why a lot of focus has been drawn to this. We can only make speculations on the reasons why, though.
Now, talking about the jury, we know that jurors A, B, C, D, and E called attorneys Jackson and Yannetti, and so their affidavits were filed in court, which formed the basis of all of this. But one of the jurors actually did a 3-hour interview online with Aiden Kearney, the famous turtle boy. And it was an eye-opener. It was really an eye-opener for a lot of reasons. And Mr. Kearney opened up his lines for people to ask him questions. And we were in a blizzard that day, so I watched the whole thing. It was 3 hours. It was snowing. I had nothing to do. And I watched. It was a real eye-opener. And we have to give a lot of credit to Mr. Kearney because, the TV stations in Boston really should hang their heads in shame for them not getting something like this. Because, in the old days, this was journalism. It really was journalism. And for them to, with the exception of Ted Daniels over at Channel 25, Boston 25, who, has scored a lot of objective points in his coverage. Most of the TV stations have been really silent. They restricted their coverage to like 90-second reports. But in any event, I digress. It was kind of shocking. This juror, Ronnie, explained how he was not guilty on all 3 counts. He went back and forth, but in the end, he was not guilty on all counts. But Turtle Boy asked him to explain the thoughts of some of the jurors who did vote guilty on count 2. What were these other jurors thinking? Why did they not go along with the ARCCA experts who said that Karen Read's Lexus never hit? John O'Keefe.
Was as a direct result of Karen was there at that time, and John was there at the time, and it was believed that John died there, therefore, right, at that location. And therefore, it seemed like, and everybody, all the witnesses were suggesting that he was never inside the house. And as a direct result, the assumption, or if you connected the dots based on the evidence that was provided to us, it seemed like there was some sort of collision with the car, and therefore there was damages to the vehicle. And with the damages to the vehicle, and that both individuals were there and present, that the cause must have been, or somehow, some sort of involvement by Miss Read. So that was how they all arrived at.
That is shocking. I mean, whatever happened to the basic constitutional standard that the prosecution, the Commonwealth, the state, wherever you are, has the burden to prove each and every element of each charge beyond all reasonable doubt? I mean, this is just outrageous that not him, but the other jurors were thinking, oh, well, she was there and he was there and the car was there. And, the witnesses all said, that he didn't go in that. So therefore, we can draw the assumption that she's guilty. That's backwards. That's shocking to me.
To lock someone away for so long, because the thing is to, and I'm not in these jurors' heads, but are they inherently placing malice with this? Are they placing like premeditated thought with this? I don't know. The whole thing is interesting. I do want to say that juror that spoke, I think he delivered it in like a clear and well-spoken way. Which indicates that he thought about it too, but it is interesting as well, like how they had such different thoughts with this situation.
And Ronnie, the juror we just saw speaking to Mr. Kearney, was unequivocal that yes, all 12 jurors in the Karen Read jury in Norfolk County Superior Court in Dedham in late June and early July of 2024, all 12 jurors unanimously agreed that Karen Read was not guilty on counts 1 and count 3. Not guilty. It was only count 2 that they were hung on. And he and some of the other jurors wanted to go and tell the judge, they wanted to inform the judge that on 2 counts, they were unanimous in acquitting Karen Read. But the foreman and some of the other, I believe the words that he used were more forceful or more prominent. So I'm not going to say bullying, but some of the other jurors who I think he said were more outspoken, and the foreman said, no, we're not going to go tell us. So that's wrong. I'm sorry. So there were a lot of other really, the interview was 3 hours, and we don't have time to get into that. So go over to Aiden Kearney Turtle Boys channel and watch it. It's a real eye opener. So with that, I don't know. This episode has run longer than our normal episodes. I don't know, Lainey. I always put you on the spot, and I kind of feel bad about it. But do you have any closing thoughts for us?
No, I mean, I'm more curious, and I feel bad I always respond with this, but I'm curious to see what people actually have to say about this, because it sounds like there's a lot of very prominent discrepancies, whether, I mean, even just the thing about, and you know, some people have been commenting this in our previous video, speculating what she was upset about and why, you know, we stopped everything and we're gonna head back. But I don't know, it could elicit such a strong emotional reaction in court. I think judges are supposed to be level-headed people, so I am looking forward, maybe not looking forward to, but I am interested in seeing what happens on Tuesday.
Yeah, my closing thought is this. We've had a lot of commenters say, when are you going to talk about this? When the hearing happened. Well, we're part-time. We're not, there are people out there that every day they're out there 2.5, 3.5 hours. I'm still practicing law full time. I was writing briefs in a federal case I'm working on. I have some discovery that's out. You know how discovery is really important? I have discovery that's outstanding. So that's what I'm doing. And Lainey has her own gig going on. And it's like, we don't have time to post this stuff. So just let us know what cases you want us to focus on. Go down, tell us what we're doing right, what we're doing wrong. I particularly, there are some people that like to bug us and say, "Oh, you're a Karen Read supporter." Well, I've tried to be objective all along, but the things I've seen in this case have made me say several times that she's not guilty. And there are a few people in the comment section that dog us and say, "How can you say that? Yeah, how what kind of an attorney are you?" All right, I would love somebody and I've how many times have I said this? If there's somebody on the inside of this case, and I know that you comment because I can tell from reading the comments, if there's somebody on the inside of the Commonwealth, and yeah, I know about the ethical standards for the attorneys, but there are other people on the inside that dog us and comment, you want to come on, we'll give you some time, all right? We'll give you some equal time. When the Commonwealth files its memorandum in opposition to the brief that we just read, we'll give it equal time. We'll give it equal time. I'll measure how much time we spent today on the habeas corpus petition memorandum, and we'll give you equal time. But if there's somebody out there that would like to come on our podcast, as you see, we have a bunch of different squares, and we can fit you in one. So that's my final comment. Thank you very much for being with us, and have a good one.
Whether you're in the grocery store, the gas station, or anywhere else, please remember to be kind to people. You don't know what they're going through. And the same goes for our comments section. We want you to comment, but be nice, be kind, be positive if you can. And thank you for watching. Be sure to like and subscribe. Have a good one.
Is entitled